Good evening, everyone. Today we have a very special guest who needs no introduction at all. It's Advocate J. Sai Deepak, who represented the chief Tanti of the Padmanabhaswamy Temple and devotee organizations such as People for Dharma and the Temple Protection Movement in the case. This case is a historic judgment and it's potentially paved the way to free Hindu temples from government control, a cause that has been fought passionately, a cause that has been close to everyone's heart for the longest time. And J. Sai Deepak, in fact, is very closely associated with the cause. So I'm very glad to welcome him on our show today. And we are hoping that he will be able to explain the nuances of the case, which we so often miss. Hi, Sai, welcome. If you could just
Namaste.
start by explaining what the case was and what your role in it was, and we can take it forward from there.
Yeah. So, see, frankly, this is one case that I've said even before that most people who have had trouble with troublesome tenants can relate to. Okay.
Sorry?
Uh, this is a case that most people with troublesome tenants can relate to. Okay. Uh, so, am I audible? Am I audible?
Yeah. Fine.
Yeah.
Yeah, you're audible.
Okay. So, in 2009, the then executive officer of the temple administration of the Padmanabhaswamy Temple asked a tenant who was a practicing advocate to vacate the premises which belonged to the temple. The tenant who was a practicing advocate responds to that particular eviction request by filing a writ petition before the Kerala High Court, challenging the very authority of the executive officer on the basis that his own appointment was illegal because the person or the ruler who appointed him had absolutely no authority to appoint him in the first place. And his entire position was based on the fact that because of the 26th Amendment to the Constitution of 1971, which resulted in the abolition of privy purses of royal titles and privileges, the ruler of Travancore was no more the ruler for all practical purposes. And therefore, they had no rights or authority to control or manage the temple. And therefore, they had no right to appoint anyone who could ask him to vacate the premises. This is what happened in 2009. And then a spate of actions were filed against the family and the ruler in the courts of Tirunanthapuram. And then the then ruler, Sree Martanda Varma, Uttaradam Tirunal Martanda Varma, approached the Kerala High Court in a separate writ petition asking for all these cases to be clubbed together because the issue in all these cases was same, which is to say that whether or not he and his family and his successors had the right to continue to control and manage the temple, and whether the 26th Amendment of the Constitution had taken away those rights. In 2011, 30th of January 2011, the Kerala High Court comes out with a verdict ruling against the family and holding that after the death of the covenanting ruler, that is the ruler of the princely state who acceded to India in 1949, after his death in 1991, none of his successors had the same right with respect to the temple, coupled with the fact that the 26th Amendment had abolished all titles and the concept of rulership, so to speak. According to the court, the temple had to be given over to the state government because nobody else was there to control the temple. So the state was asked to constitute a trust to control the assets and the management of the temple completely. And the court went to the extent of saying that all the sacred vaults of the temple must be opened. And every article in the vault must be inventorized and put on public display in a museum within the temple so that people can come and look at those articles by paying a fee. And the court did not strike a distinction between practicing Hindus visiting the temple and non-practicing Hindus or non-Hindus visiting the temple. Okay, so all of this happened. Then the royal family appealed against this particular judgment before the Supreme Court. They got a stay on the judgment, but the administration of the temple was handed over to a committee or a host of committees which the Supreme Court created for administration until a final disposal of the matter. And that is the matter which has reached a final culmination through the judgment of 13th of July 2020. That's what has happened. As far
So,
as my
Sai,
involvement,
who were you representing, and what was your involvement in the case?
in fact, there's a lot of confusion around this. I don't know for what reason, because the judgment is crystal clear in this regard as to who argued and who we were arguing for. For some reason, people have not bothered even reading through the judgment on this particular issue. A lot of rumors are floating on Twitter for some reason. So let me just clarify this. The primary parties to the case were the ruler of the royal family, other members of the family, and the temple trust. These three entities were represented by Sri Krishnan Venugopal, senior advocate, along with advocate Sham Mohan, who represented the ruler, Sri Arvind Datar, senior advocate of the Supreme Court, a renowned constitutional expert, represented the temple trust, Sri M.K.S. Menon represented other members of the royal family, and I represented, along with Sri Suvidat Sundaram, the chief Tantri of the Padmanabhaswamy Temple, the organization called People for Dharma, which is known for its role in the Sabarimala case, and another organization by the name Temple Protection Movement, founded by Sri M.V. Soundararajan, the former chief priest of the Chilkur Balaji Temple. They were present in these proceedings as devotees and as Vaishnavites. So for all practical purposes, I represented intervener organizations. We entered the proceedings in 2017, and we were heard extensively from January to April 2019, along with other councils, when the matter was taken up for final arguments. In addition to that, a lesser known fact is that the union government was represented at least for 3 years in these proceedings, from the 20th of March 2017 at the very least until the 10th of April 2019, when arguments concluded. And while they were present in court through their counsels, there was no submission made on behalf of the union government for reasons best known to them. The state government of Kerala was represented by senior advocate Jaideep Gupta, and of course the tenant, the tenant who created all the trouble, was also represented by a set of councils. And other stakeholders within the temple management were represented by lawyer Usha Nandini. Other than these parties and these councils, I don't remember seeing anybody else in court during these proceedings, at least since 2017. These were the only people who were active participants in the proceedings. The union government was not an active participant. It was a silent spectator to the proceeding for over 2.5 years.
Okay, so before we go forward, I would also like to introduce Mr. Ravi, who is the trustee of People for Dharma, and he's just joined
Namaste.
us. So, namaste, Mr. Ravi. Thank you for joining us.
Namaste.
So now that we've introduced him, we'll carry on discussing the verdict. Now, Sai, one question is, that comes up with the opening of the vaults. I believe it's Vault B, the sixth and the last vault, which has yet not been opened.
Yes.
And the judgment has left it on the Travancore family to decide whether they want to open the vault or not. So can you tell us a little about the significance of this vault and the rest of the vaults, and why the vault should or should not be opened, or whether the Travancore family wants or does not want to open the vault?
Right. The best person to answer this question is Raviji, but to the limited extent I address this question, let me just answer your question. Now, Kallara B is effectively, or the Vault B is effectively the contentious vault, which has been in controversy for a very long time, because the amount of treasure contained in it and all that has been the subject of wild speculation. Okay. Now, most of these vaults are situated in places which, as devotees, people believe it is meant to preserve the balance, energy balance of the place. Okay. Most importantly, the belief of, let's say, the temple is that at least some of these vaults, and Kallara B is located at a place which was consecrated by Lord Parashurama himself. That is the tradition of the temple. And for all practical purposes, these vaults are not meant to be opened because they preserve what is known as the Chaitanyam, or the energy of the place. Okay. English does not do justice to the actual sentiment behind the word Chaitanyam, but energy is the crude translation. Now, Kallara B, according to the family, must never be opened, should never be opened under any circumstances. The Supreme Court has effectively left it to the discretion of the administrative as well as the advisory committees to take a decision on this issue. But both these committees are ultimately answerable to and operate under the supervision and control of the ruler. Therefore, the decision is of the ruler, and the ruler is bound by the tradition. Therefore, the position of the royal family in the Supreme Court was that this vault should not and is never meant to be opened because tradition bars it and prohibits and forbids it. That's the basic position. And since 2009 onwards, successive governments, at least in 2009 to 2011, then dispensation was very keen on getting getting access to the vault and the so-called treasures inside it. It's not treasure according to us. This is the property of the deity, and nobody else can have access to it.
Sai, 1 second, I have another follow-up question. So, what was the significance of the court saying that all the inventories, so to speak, of the treasures inside the vault have to be recorded and put in a public domain? Because, as far as a devotee would understand, it is the property of the deity, it is the property of the temple.
Right.
And since it was under a communist government, which was Kerala, in fact, any government, whether it's communist or right wing or left wing or whatever it is, it was under a government control. So,
Right.
how do you see the significance of the Kerala court saying that the vaults A should be opened and B, the inventory should be recorded and put into public domain? And how would that compromise the A, if there is treasure, then the treasure, and B, the rights of the devotees?
So the Kerala High Court invoked a certain provision of the Constitution which deals with the concept of escheats. And what it effectively translates to is that assume for a moment that a certain piece of property of public importance is left orphan, okay, or in public interest, it's possible for the state to take over that piece of property, okay. So the doctrine of escheat or the principle of escheat effectively hands over that particular piece of property to the government, so to speak. And this is a specific provision that the court actually invoked. This is Article 296, which is property accruing by escheat or lapse or bona vacantia, which is to say, if there is nobody who is responsible for it, then the state takes it over. Okay. And this is in a significant way a continuum of the doctrine of lapse, which was adopted by the British. If there is no person who is there to occupy the throne, then the state takes over. Okay. Now, the interesting part is the court effectively not just asked for inventorization, but also monetization by creating a museum within the temple.
Okay.
And opening it to three categories of people: devotees, tourists, and the general public, which means a place of worship was effectively converted to a place of tourism and revenue collection.
Right.
Okay. I'm not sure that even invoking the doctrine of escheat, an order or a direction of that nature could have been passed, because the idea should be to preserve the sanctity of the temple and to preserve the integrity of the deity's property. Which is why, assuming for a moment that the court was right in coming to the conclusion that the royal family did not have the right and the state must take over, could the direction have gone to the extent of opening it up to everyone? Then what happens to access over that particular property, and who benefits from the proceeds of that particular property? So for all practical purposes, I think the direction was fairly open-ended in that particular regard, came in the way of religious sentiments and infringed, according to me, fundamental religious sentiments and rights. So this is where the problem starts.
So I would like to go to Raviji now. Raviji, first question is, how do you see this whole verdict? How is it playing out? And then lead us to the whole issue of the secular state versus temple management. Why the hell is state, mingling into the affairs of temple management? Why is it not with Hindus or maybe followers, or somebody else should have the right and not state? If state at all has right, then why are they not managing, say, mosques or churches or those kind of religious institutions? Can you switch on your mic? Your mic is off. Yeah.
That's fine.
Can you hear me now?
Yeah.
So let me talk about the judgment first. To me, it is a very welcome judgment, because what the High Court envisaged was nothing but desecration of the temple, a complete desecration. Compared to that, the current judgment actually paves way for the traditions to be maintained. All the religious aspects are left to the chief tantri. Customs and traditions have to be followed. So there is no reason why a devotee has to feel bad about this judgment. Yes, the only thorn you can say is that there are at least two positions which are given to the government, though the committee is still under the control of the trustee. Now, coming to the government control of temples, I would say that Hindu Janamanas, the Hindu masses, are the primary reason why the government has been able to take control of our temples. Right from the 1920s under the British, when they first brought the Madras HRC legislations in the erstwhile Madras presidency. It was initially meant to be for all religious endowments, where the Muslims were able to create enough ruckus and force the government to take a step back. uh, our people, our ancestors failed to do it. So Hindu property became, very easy to poach upon for the government. And since then, if you look at it, even in 1950s and 60s and 70s, there's never been a real mass movement to throw the government out of the temples. Perhaps our ancestors at that time thought that the British have been thrown out, the new government will be very dharmic in nature, and maybe there is nothing wrong in them supervising the temple. I don't know what went through their mind, but the general Hindu public were not uh, seized of the problem that is being created with these various legislations. And over a period of time, we see that the so-called boundaries of the secular role within the temple kept on increasing, uh, sort of limiting the amount of religious space within the temple. So much so that even the appointment of a pujari in a temple became a matter of secular issue. Uh, in fact, there is a funny saying which Ramesh ji always points out, and it is not merely a saying, but it's something which was argued in the courts, and the court actually adjudicated upon it. That you take a coconut to a temple, you offer it to a deity, and then the coconut is brought out of the temple, where the boundary of the religious starts and where it ends. So it was decided that till it enters the Garbhagriha, it is secular, and once it comes out of the Garbhagriha, it is again secular. So the prasadam became a secular item. So, and the unfortunate reality is, yes, the government has taken for granted the Hindu rights. That has happened only because where the minorities are very keen about protecting their place of interest, their place of worship, we have perhaps not been so uh, active in this regard. I would say that the very idea of temple freedom has started gaining momentum only in the last 1 decade. Certainly not before that.
So,
Sujit, I
maybe
have a
Nupur has a question
question.
to
Yeah,
Sai. Yeah.
I have a question for Sai. Now, Sai, in the verdict, it's mentioned that only Hindus would be a part of the temple management committee.
Right.
And there is certain chatter that the verdict does not free the temple completely from government control. And
Right.
even though there are only Hindus in the temple management committee, but there would be appointees of the government as well. Can you clarify or explain how this really works?
See, I think the criticism, I appreciate the sentiment behind the criticism and I appreciate the intention behind the criticism, because now finally there is clarity as to what is negotiable and what is non-negotiable. And I'm very happy that there is awareness within the Hindu community that there are certain aspects which can never be compromised on and which can never be and should never be negotiated upon. So I'm very grateful for the sentiment behind the question. Now, unfortunately, in the facts of this case, I don't think people have paid attention to the specifics of the judgment in this regard. And there's a decent chance that everybody is getting carried away with the chatter on social media. Okay. So, what is it that has happened so far? The requirement that every member of the administration should be a Hindu was always present in the Travancore legislation, okay, which is the Travancore Cochin Hindu Religious Institutions Act of 1950. That was always there. There is no doubting it at all. So what the court has done is to reiterate it just so that nothing is left to anybody's imagination, because certain state entities and state nominees are being appointed here. That shouldn't send the signal that anybody and everybody can walk into this particular institution willy-nilly and have a seat at this particular table. Okay, so that's one of the reasons why the court has actually come to that particular, or let's say, made that finding very, very clear. Secondly, what the court has also done has clarified that it's not enough for you to be just a Hindu, because there is such diversity in Hindu traditions and sampradayas. You must have faith in the sampradaya of this particular temple for you to have a seat at this particular table as far as the administration of this temple is concerned. Okay, because there was an instance in this case where one of the amicus curiae appointed by the court to let's say review the let's say the situation with respect to administration wanted Hanuman Chalisa to be chanted at this particular temple on the ground that it's a Vishnu temple and therefore Hanuman Chalisa must be read or chanted. And he was not even appointed with respect to religious practices. The primary scope or the mandate was only with respect to administration related issues and even inventorization, nothing beyond that. So we were the ones to actually point out that these kind of interference with religious practices is not the business of any person who is appointed by the court. Okay. And therefore, the court's spirit is to prevent any such future interference. There was a specific history to this particular clarification. Two, the sense in which I think, or the problem where the criticism comes from, or let's say the sense of the criticism is that as part of the administrative committee, which the court has appointed, the 5-member administrative committee, there are 3 people who are perhaps from the establishment side. The first one happens to be the district judge, who shall be the chairperson of the administrative committee. The second is the nominee from the Ministry of Culture, the Union Ministry of Culture. The third is the nominee from the state government of Kerala. This is as part of the 5-member administrative committee. Now, coming to the advisory committee, you have someone who is a retired judge of the High Court appointed by the Chief Justice of the High Court as a member of the 3-member committee. Now, let's just explain how these committees work and how it works. Let me just make it very, very clear.
Yeah.
What does the Act say first? Let's be clear about it. And what has the court done? I'll come to that next. Okay. The Act has a specific chapter, which is chapter 3. The specific title of the chapter is Sree Padmanabhaswamy Temple. And therefore, this chapter is dedicated to this particular institution. And this entire dedication is a consequence of the treaty obligations, the covenant obligations entered into between the Travancore princely state and the Indian Union in May 1949, wherein the Indian Union promised to the then Maharaja that he and his successors shall have complete dominion and say with respect to the administration and management of this particular temple. Okay. In fact, the court has recorded that particular history as part of paragraph 7 of the judgment, where it extracts from the book written by Sri V.P. Menon, who was the right-hand man of Sardar Vallabhbhai Patel, from his book, The Story of the Integration of Indian States. Okay, or Story of Integration of the Indian States. Okay. Now, therefore, what happens under sections 18 to 23, chapter 3 of the Act is, the Maharaja gets the right to appoint an executive officer who shall be responsible for the administration of the temple. Now, that executive officer has been replaced by the administrative committee, the 5-member committee. Okay. Now, therefore, most people are saying the executive officer who was appointed by the Maharaja is now replaced by the administrative committee. And this administrative committee has 3 entities or 3 people from the establishment side, and therefore there is a problem. Okay. What they forget are the threefold aspects. What? The administrative committee as a suggestion came from the Maharaja himself.
Okay.
Which is recorded in the judgment. The suggestion to constitute an administrative committee and the composition of the committee came from the Maharaja himself. The only distinction was that as opposed to the district judge, the Maharaja wanted a retired IAS officer of the rank of the secretary to the state government to be appointed. Okay. So the court has accepted largely the suggestion of the Maharaja and made one change. Why? Section 18 says that the executive officer shall operate under the control and supervision of the Maharaja. Now, if the administrative committee has replaced the executive officer, it performs the administrative functions of the executive officer but continues to be under the control and supervision of the Maharaja, because that is already specified in the Act. So nobody has bothered to read the specific provision and the context in which this replacement has happened. So one individual, namely the executive officer, has been replaced by the administrative committee. The administrative committee does not prevail over the Maharaja but acts under the Maharaja. So that's one. Second is the advisory committee. The advisory committee is the primary committee that advises the Maharaja under section 20 of the Act with respect to the discharge of his functions. So all high-level issues, policy-related matters are undertaken by the advisory committee, and day-to-day administration is undertaken by the executive officer, now replaced by the administrative committee. Now, this advisory committee also is traditionally appointed by the Maharaja under the Act, and therefore, for all practical purposes, both the committees come under the stewardship, under the control and supervision of the Maharaja, because you see, the court has effectively recognized his role as the guardian of the temple. So you can't recognize the role of guardianship on the one hand and then constitute committees which effectively prevail over the guardian. So that's not the sense, nor the sentiment or the intent behind the court structure. So on the top, you have the ruler, who is referred to as the trustee in the judgment. Under him, you have a three-member administrative committee. Under them, you have the three-member advisory committee, and under them, you have a five-member administrative committee. So, for all practical purposes, the control has reverted to the hands of the Maharaja. Therefore, status quo ante has been restored, which is the position which existed prior to the judgment of 2011 has effectively been restored by ensuring that the control reverts to the hands of the ruler of the Travancore royal family. That is what has happened.
I think the main doubt or the fear here is that the appointees of the establishment, you have no sort of checks and balances to ensure that they are actually devotees and they're actually followers of the faith,
Right.
and not simply appointees. But you're saying that the ultimate control rests with the Maharaja, which is now the Travancore family, and hence that fear is sort of assuaged by that?
See, there are two reasons why that fear. I'm not saying that the fear is misplaced entirely. I'm merely saying the exaggeration of that fear is overshadowing the outcome. Okay. So, what is the remedy that you have in those eventualities? Is the simple question. What can the Maharaja do? Are the Maharaja's hands completely bound and tied up? That's the simple question, right? Now, one, assume for a moment that there is a mischief monger who populates that particular committee. One, the immediate check is the Maharaja doesn't need to listen to him. And especially in matters of policy, which the court has identified, that nothing can be done without the consent of the Maharaja and the approval of the Maharaja, especially in those matters which affect the fundamental character of the temple and the religious sentiments of the believers. That's one. Okay. So no member of any committee can prevail over the Maharaja in general, but certainly not with respect to these aspects. Second, assume for a moment that somebody has chosen to gang up against you, and they are affecting the interest of the temple, the interest of the devotees, and traditions, or even secular administration. Why don't people even ask themselves, if the court has done something, don't you go back to the court saying, I need a revision of this particular structure or a review of this particular structure, because it defeats the very purpose of its constitution, and therefore it is coming in the way of the day-to-day administration or even policy-related issues? See, you're not now held hostage to the legislature, because if the legislature does something, you have to wait for an amendment. But if the court has done something, you have every right to go back to the court if you believe that this particular structure is unworkable, infeasible, and impedes the administration of the temple. That's exactly why I said in another place that everybody wants to pass off as a lawyer and shoot from their hips in the dark as if they know everything about the law. Even lawyers can't claim to know everything about the law and every law. Okay. So some sense of, or some modicum of restraint is called for when you're speaking of a subject which is not exactly your area of core competence and specialization. That, I think, is largely missing in the debate. So while I respect the well-intentioned concerns, as opposed to passing it off as final conclusive opinions, I would have appreciated it if people had come out with questions, saying, how does one deal with the situation? Is this situation addressed in the judgment? Is it open-ended? Instead, people have passed off their questions as final opinions and said, this is how it's going to be. Therefore, as Hindus, we are always destined to lose. If that's how you believe, I don't think you should be part of this movement at all. That kind of pessimism and negativity has no place in this movement.
Okay. Now I have a question for Raviji, and it is in the broader aspect, not pertaining particularly to this case only. Temples has been being seen as a tourist place, and that's why this bullshit of feminism and not recognizing the rights of deities, prevailing deities, that this is my home and I will decide how it functions. When we do this pran pratishtha of a deity, he takes a form, means he's a legal person. I think Mr. Sai will be able to approve that. So why this whole my home is being violated by people who might not necessarily be Hindus or even be offending to Hindu faith itself? So this whole thing of, we have seen that in Sabrimala and we have seen this in Shani Shingnapur. The nature of the deity, the brahmachari nature of the deity, that has been violated upon, and court is saying, court is seeing the temples as tourist places or just what you can say, a structure, that's it, a building, not necessarily a dharmic structure which has its own nature, which has its own, energy, vibes, and it has to be managed and respected by the Hindu or the followers itself. Like we don't mingle in the affairs of other religions or other religious places. So please elaborate upon this aspect of temple and temple management, and how courts or the government itself sees it as some tourist place, or anyone can come and spread on their wokeness of.
Okay. See, I would actually add one more point as well,
Yeah.
because I would say it is not merely a case of non-Hindus or those not believing in the deity taking part of the temple management. It is a bit more than that. Every single temple of Hindu Dharma belongs to at least one sampradaya, and each sampradaya has its own subsects, and each of them have their own specific rules and regulations, rituals, and rites. So even a concept of all Hindus coming together to manage a single temple falls flat on face, because, for example, I may be a Vaishnava, but I belong to the Vadagalai subsect of Sri Vaishnava Sampradaya, to which maybe the temple at Kanchipuram belongs. But let's say the Udupi Krishna temple, which belongs to the Madhva Sampradaya of the same Vaishnavite school, I really don't have any right over the temple, except perhaps as a devotee, I can go and make my obeisance to the deity. That's it. So this clear differentiation between the various sampradayas and their practices is something which is completely lost in, you can say, the legal world, or even among the government. What has happened is a kind of Abrahamic view of Hinduism. You look at all temples as similar. In fact, in Shabarimala judgment, one of the statement made was that uh, disallowing women is not a central theme of Hinduism. I mean, is there anything called a single Hindu way of doing Pran Pratishtha or single Hindu way of doing puja? Of course not. The very essence of Hinduism is its diversity of worship, its diversity of panths, of sampradayas. So what they are trying to do is homogenize everything, and this homogenization is. Uh, am I lost?
You were off for a moment. Please speak.
Hello.
Go on.
Yeah, go on, go on.
Can you hear me?
Yeah, of course.
Just one moment. I'm unable to hear anything.
Voice is a bit down, but please.
I think the earphones must have come off.
I'm sorry. There is some internet
Yeah.
connection problem here since afternoon.
Yeah, we can hear you now, Raviji.
Yeah.
Please. Yeah.
So, okay. So the problem, at least that I face here, is that uh, there is a attempt to homogenize everything, and when you try to homogenize Hinduism, you literally destroy Hinduism, because the dharma of this land is about the various sampradayas, the various denominations, and their practices. We are not Abrahamics. We have nothing called one way, one book, and one paddhati.
Monotheism.
So,
Yeah.
of course, so and it's even more than monotheism. What they expect from us is monopraxy as well. The similar practice everywhere. That is something which is not going to happen here. In the same Kerala, there is a temple where men are not allowed to take part in a festival. There is another temple where every woman is offered puja as Devi, and men are not even allowed to go inside. So, what are you going to do about those places? The issue is you try to first homogenize the place, and the reason behind homogenization, as you said, they have started looking at these places as mere places of worship and not as residences of my deities. A church may be a place of worship. A temple is not a mere place of worship. You can worship from your home. You can worship while you even travel on the way. For us, a specific place is not required to do worship. We go to the temple to have a darshan of the deity. A temple is a residence of the deity, right? And what do you do in a person's residence when you visit the place? You follow the rules which are established by that person for his household. Each residence is his own castle, the owner's castle. That principle has to apply here. So this idea of temple being a mere place of worship is a legal fiction which has to be set right, in my opinion. It is much more than a mere place of worship. It is a residence of my deity, who is a living being according to me, who is worthy of all kinds of respect, whom I treat as the ruler of the world. In fact, that is the primary common thread through all the temples. The primary, or the what you call the Mula Murti, the most important deity of any temple, that deity is treated as the ruler of the universe within that temple. So when a devotee enters, he enters to have darshan of that ruler in his or her darbar. And for us, the Murti is a living representation of the deity. So in what way can you compare it with other places? I have no idea. But somehow these people make a comparison and they go a step further. They think that just because we go and have a darshan of the deity, maybe they think it is a museum. I really don't know what goes on in the minds of these, leftist influenced babus. But the primary problem is this: they have no idea about the nature of my temple. They have completely changed the definition of the temple. Result being that, as you said, it has become absolute nonsense, where feminism or tourism, only these things are primary. I mean, imagine this: when even I don't want to really take pot shots at the party, but this is a very primary example I can give. When people talk about the recent Chardham Act, one of the reasons given by those who support the act is that it will increase tourism in the place. For goodness sake, I don't want tourists in my temple. I want believers in the temple. And even in Padmanabhaswamy Temple, we have seen this problem since 2011, when the news was leaked out about the treasure in the temple. What used to be a very beautiful place of doing meditation on the deity, and what used to be a very sincere place of devotion, where people used to adhere to all rules and regulations, continuous degradation started happening, because it was not merely the believers who came, but those who did not have any faith in the deity, but simply wanted to come and look at what do you call the wealth or whatever is there in the temple. So this was the primary concern for most of the devotees. I mean, you have converted a place where continuous worship was offered to the deity right from at least 300 BC, if not earlier, even as per the historical records available, because this temple is mentioned in the Sangam literature of the ancient Tamil period. In Paditrapattu, the temple is mentioned. Even the temple's annual Arat festival is mentioned. So such a temple, where devotion to the deity was the most primary thing, was turned into a place of tourism for these people who came to literally gawk at the temple's wealth. No, I don't want that. That is certainly not the purpose for which the temples were built. But perhaps for the government, it is required, because they see these temples as places of
which can earn money.
Earning money, or maybe as milch cows and nothing else.
Sai, now I want to ask you a question. Are we very badly represented, means our dharma, or in cases pertaining to these temples, wherever we have lost, are we not adequately, means academically adequate representation? Is is that lacking from our side? Are there not good lawyers not representing our cases? Why are we losing when we have such clarity of thoughts about a deity being the honor of that house and having its own rules and regulation, pluralism of Hindus, polytheism of Hindus, that we will go by our own, ways and means. Then why are we losing out? Why Shani Singapore lost out? Why Sabrimala? And it might be a precedent for coming, judgments to come. What is the problem there?
I just need a clarification from you. Are you putting this particular judgment also in the category of loss?
No, not this one. I'm just
I
trying to
know
understand.
Sai so well. I knew the moment Ajit asked it, this is the comment that's going to come from Sai.
I just
Because
want to
depending on the
know.
nature of the comment, my response will come. See, one thing is for sure. So, since you don't believe that this is a loss, I'm assuming that you're saying that this is a welcome departure. I hope that
Yeah.
is what you're saying.
Yeah.
See, here's what I think I see this as. Let's give credit to a lot of people who have worked in the past. Okay. And if I were to make the statement that prior to this team taking up these matters, there was no one to represent or do a good job of it, then it would be extremely arrogant and it would do injustice to a lot of people who have worked on these matters. Okay. Because several people for several decades have been doing this, but you have to realize, and this is something that most people don't seem to still they don't seem to be able to wrap their heads around, which is we assume that a judicial process is an entirely legal and academic process. Okay. Every process in a democratic republic responds to the people's voice significantly in one way or the other. The question that we must ask ourselves, firstly, is exactly the issue that Raviji put his finger on. If the Hindu community has lost its sense of direction and its, let's say, its moorings and its own importance towards its places of religious worship, how on earth do we expect the same kind of results in court? Because whatever you take up is seen as an aberration, because most people are bound to assume ये लोग उठ के आ गए, इनके पास और कोई काम नहीं होता है, एक एकेडमिक पिटीशन फाइल कर रहे हैं, ये तो लग्जरी लिटिगेशन है, बाकी लोगों को कोई तकलीफ नहीं है, इनको क्या तकलीफ है, बस फेंको मैटर को बाहर. Okay. When the community effectively expresses its seriousness of intent in democratic ways and in constitutional ways, the message is bound to reach every forum. But if only a handful of people on a regular basis in every generation are the ones who fight lonely battles or who are outnumbered by people from their own community who do not believe in the value in these battles, how do you expect any kind of mass multiplying effect as far as the outcome is concerned? Okay. Now let's come to the empirical data on this particular issue. Okay. There are judgments from 1954 till 1965, till 1980s, till 1990s, and even 2014, which Dr. Swamy fought in the Chidambaram case, which are successes, by the way. They are successes. So we haven't done our reading to actually take stock of the situation as to how many places we have lost and how many places we have won. Because once Sabrimala first round is propped up, but the fact is today the situation has been restored in Sabrimala thanks to the review petition, and that is largely because people understood the gravity of the situation. So those who wanted to effectively highlight this loss, it backfired on them when they realized that the community was responding, because then the situation has again been reversed. Okay. Ram Janmabhoomi, why do we forget? What a significant victory, what a landmark victory, right? Kudos to Sri K. Parasaran, to Sri C.S. Vaidyanathan, to Sri P.S. Narasimha, and a host of other lawyers who represented the Hindu side. So all these lawyers exist, and these are some of the finest brains on constitutional law, some of the finest committed minds on Indian constitutional law that you can find. So it's not lack of representation. But what happens is, so there are multiple aspects. One, representation is one aspect, but community participation in these causes. कोर्ट में फाइल केस को दायर करके अगर आप चुप बैठेंगे तो आपको लगता है कि गाड़ी अपने आप चलेगी, ऐसा थोड़ी होता है. The community must constantly follow up, the community must constantly show an interest. In the Padmanabhaswamy case, every stakeholder to that particular temple stepped up to the situation, stepped up and he said, I will make myself count and participate in these proceedings and present my point of view as the stakeholder from my perspective as to how the tradition must be sustained and how is it important. The Tantri effectively stepped up. Every other member of the traditional management structure, the Atara Yogam, stepped up. How many such instances do you find? So when we assume that एक वकील से सब कुछ हो जाता है, नहीं होता है. एक वकील से सब कुछ होता है, नहीं होता है. What we realize is that community participation strengthens the hands and the morale, both in a practical way as well as in a mental way, as far as the lawyer is concerned. And the forum is aware of the fact that this particular outcome or this particular matter matters to the community. Okay? Yes.
I have now 2-3 follow-up questions from whatever you have said. And I'm sorry if I put you in a tough position, okay?
No, please.
It's my job to put you in one.
Yeah. Okay.
So we got one question, which basically says, why do we blindly fight the government control of temples? In most cases, government takes control because of the mismanagement of trustees. Now, this is me playing the devil's advocate. So that's one. And an extension of that is, can this verdict in the future be used to free other temples which are under government control? How realistic is the broader aim of freeing all temples from government control? That's part one. And after you answer that, I'll ask you part two.
Okay. See, the first part is this. Is it anybody's case who's fighting for freedom from government control that corruption would be completely absent if the temple were to revert to the community's hands? No, that's not the answer at all. I don't think it's anybody's position at all. Is it anybody's case that in every instance where the government interferes, there is no case of corruption and it's, let's say, a malintent behind which the government comes into that particular institution? No, that's not anybody's case. So let me assume for a moment the worst possible situation against my position. What is the worst possible situation? 100% of temples in this country are corrupt. 100% of temples and 100% of every member of the administration of every temple who comes from the community is corrupt. एक मिनट के लिए मान भी लेते हैं. Okay, I'm taking that worst possible assumption and I'll deal with it on the law. Even then, the government is bound by the constitution when it comes to temple administration. And what does the government say? What does the constitution say? That the government's role is interventionary, it is supervisory, it is meant to intervene for a specific limited period, set things right and get out. That is what the constitution mandates, and that is exactly what the Supreme Court has said in the Chidambaram case. As well as in the 1965 judgment, there's another judgment. So from 1965 to 2014, the Supreme Court has been making it abundantly clear that no amount of mischief can effectively justify the state's continued, open-ended, infinite presence in the administration of the temple. The government's role is limited to limited intervention, surgery karo, theek karo, or nikal jao. That's the basic point. Okay? So I am saying even in the worst of circumstances, this is what the government is supposed to do. And that is what the constitution requires the government to do. So that's point number one. Point number two, that answers your question, which is to say, assuming that there is corruption in any place, how can the government say, I will run this place for eternity? Which government can claim to be 100% corruption free? And if your job has to come in to basically set things right, and you have not been able to set things right for 70 years, then there's a problem with your management, not with anybody else's management. If for 60 to 70 years, the government deems it fit to sit in a certain institution under the name of setting the management right, that means it has taken you 70 years and there is no reason to trust you any further. So please get out. Okay. 3. Where is the government even attempting to strike a balance between community participation and state interference? It is 0 or nothing, or rather, let's say 0 or 1. The government is not even talking of a middle path. No government is talking of a middle path. Okay. Yeah. 4. Are every institution of other religions free from corruption? Is that our belief? Is the government taking over the institutions of other communities? Is the government even interfering with the institutions of other communities when there is a case of mismanagement pointed out? No. In which case, assuming that this is a country where everybody is to be treated equally under the law, and that assumption is rebuttable, of course, I am simply saying as long as that continues to be the assumption, Why are we subjected to this exclusive treatment of government entrenchment in temples? There is no answer either in facts or in law to justify what the government does. That's the first answer to the first limb of your first question. What is the second question? What happens
Can
in the...
this can this verdict be used in the future to free other temples, and how realistic is the broader aim of freeing all Hindu temples from government control?
So this is what we did in this matter before the court. Our position before the court had three major limbs. The first limb was specific to the facts of this temple, which is to say that there is a specific treaty, a specific covenant under which this government, or rather this temple, enjoys a very special relationship with the Travancore royal family, and therefore Article 8 of the covenant is not affected by anything which has happened under the Indian Constitution, and therefore that particular relationship must be protected. So a good number of documents which have been cited by the bench in the first 30 to 40 paragraphs, capturing the history of the entire case and capturing the history of the covenant. At least 40% of the documents have come from our end because they were not even presented in court by others. Okay, they presented what they deemed fit is what is important, and we presented what we felt were important. But we were the ones to place before the court the legislative debates with respect to the 26th Amendment of 1971. We presented the interim constitution and a host of other documents. So that particular limb of our argument has been accepted by the court because all three councils representing all three pro-temple parties were on the same page with respect to Article 8. So our position has been captured in paragraph 42 of the judgment, where every limb of our argument has been detailed in that particular thing by way of a broad summary. So this is one limb which stands accepted. And in fact, anybody can look at the written submissions that is available on the website of People for Dharma, as well as the day-to-day updates of the arguments that we had given in court in 2019. It's available on the Twitter handle of People for Dharma, and they'll see a word-to-word correspondence between the language used in the judgment and the language used in the written submissions on several aspects, especially with respect to Article 8. So out of the three things that we raised, we succeeded in one. Now, what are the other two? The other two are the ones which relate to your question. So the other two, we said Articles 25 and 26 apply to this temple as well as to other temples, and we broadly said that this temple enjoys a denominational status under Article 26, and the relationship between the royal family, that is the ruler, and the temple is not just protected by Article 8, but Article 8 itself is a representation of a religious relationship that is protected by Article 25(1). Okay? Now, that particular limb, the court said, I don't need to get into this for two reasons. One, nobody raised it before the High Court. That, according to me, is a backhanded compliment. That some of the most obvious arguments with respect to religious traditions and protection, we were the only ones to raise it. Okay. Now, the reason why the court does not accept it also is because it has arrived at the same conclusion through Article 8. If I reach the same conclusion about the sanctity of the relationship through Article 8, why do I need to get into further academic inquiry? If I prove 1 plus 1 is equal to 2, I don't need to prove 0.5 plus 0.5 plus 0.5 plus 0.5. That's what the court is saying. So that is why this particular limb of the argument, the court does not say Articles 25 and 26 don't apply to this particular situation. The court is saying, I don't need to look into this question. That is the language used in paragraph 109 of the judgment. Now, what is the third limb of the argument? Our third limb was, there is an article of the Constitution called Article 363, which effectively says any issue that relates to a covenant or a treaty should be decided by the President of India, not by any court, not even the Supreme Court. So we said, if the Supreme Court itself does not have jurisdiction over this, how did the High Court pass a judgment? Okay. So we said the moment the writ petitions were filed before the High Court should have escalated to the Honorable President of India, because that is what the Constitution requires. The court has rejected that argument. But the one argument that the court has consistently upheld, which we have also contributed to, is Article 8. Now, therefore, what happens? There is no finding on Articles 25 and 26, right? To that extent, the extrapolation of this outcome to other cases is limited. Okay? But we don't need this judgment to prove our cases, because we have several other judgments to show our case on Articles 25 and 26. Now, how does this judgment help in its future utility? There are similarly placed temples across the country which belong to royal families and which have now been taken over by state government. Okay? So all those royal families which have been similarly affected can take heart and direct support of this particular judgment to say, if you have chosen to protect your obligation to one particular family, why not us? And why not our institution? And why not our relationship to that particular institution? Mysore is a very prominent example. Okay. So for me, there is a limited extrapolation possible, but the big picture extrapolation is, which people don't forget, or other people forget conveniently, is that in 2020, in a modern, secular, still socialist, because that's what the preamble continues to call itself, India, with this kind of mahal, a relationship between an erstwhile royal family, a royal family of an erstwhile princely state, and its religious institution of Hindu character has been recognized by the Supreme Court of India. So, to answer Ajit's question, for the first time in our living memory, in this generation, you have the highest court of this land delivering a victory for a Hindu tradition. And this is not the product of any solo act. This is a team act. I need to clarify that abundantly. Yes. Next
Now,
question.
I have one question which probably is not legally sound, but
Right.
in my mind it makes perfect sense. Now, since
Okay.
we are talking about freeing Hindu temples from government controls and the rights not just of the devotees but also of the deities, it leads me to another act, which is Places of Worship Act 1991. Now,
Right.
I don't think these two are legally connected, or correct me if I'm wrong. I'm not really sure what the legality is. But when you're talking about the deities and the devotees having a right over their places of worship,
Right.
then you also talk about these temples where the deities were there, where the devotees should have a right, but they
Right.
cannot legally contest their right because of this specific act, which is Places of Worship Act 1991.
Right.
Now, can you explain to me, is there a legal connection at all between these two issues? And if not, then how does the second problem get resolved?
One legal and let's say shastric or scriptural correction. Deities not were there, deities are there still.
Yeah.
Okay. Because according to us, once the consecration happens, the deity lives there for eternity until we actually initiate a process asking that energy to vacate the place. That's the belief. That's the tradition. So in every occupied religious site, which was of Hindu character, continues to be of Hindu character because according to us, our deity continues to exist. Okay.
Correct.
And that is something that the Ram Janmabhoomi judgment staunchly and strongly recognizes.
Right.
Okay. That's point number one. Point number two is this judgment may not have a direct impact, and I'm frankly, unless and until I'm pushed to think outside the box, which you always do. Okay. I'm not sure of its direct implications of that particular on that particular legislation, but that legislation in itself is frankly as unfair and unjust as it gets, considering the global movement on anti-coloniality and decoloniality against oppression and whatnot. I think we should start an HLM movement in this country, because ultimately here is a situation where over 44,000 sites are occupied sites, and we are being told that be happy with 3 sites. We will bargain 44,000 and X number of sites, or 49,000, 43,000 sites in return for 3 sites. So here is again an Abrahamization of this bargaining thing. How can I give up on behalf of anybody else? It's a question of denomination, it's a question of sampradaya, it's a question of faith in different places. The contextual and the local feelings are so strong. How can I bargain on behalf of anybody else? We were apparently told that take Ram Janmabhoomi and don't talk about anything else. How is that even possible? I don't even have the right to give up somebody else's house.
Which is what I'm saying, that in both these cases, aren't the rights of the devotees and the deities being infringed upon by the government and by the legislation?
The 1991 Act is a legislative infringement of the constitutional freedoms and the fundamental freedoms of the Hindu community.
Right.
Okay.
So shouldn't it automatically come under the gambit of free temples from
Course it
government
is.
controlled banner?
In fact, as part of the work that People for Dharma, Indie Collective, and others are doing, it is not limited to asking governments to exit from existing temples which are functional and operational. We are saying as part of this larger ambit is you have to address the question of 44,000 temples across the country which have been taken over by others, and where we have been forced to shift our temples to accommodate people who came and destroyed the original sites of worship. The Mylapore temple in Chennai is a prominent example. Anybody goes to Mylapore Shiva temple will immediately see that outside that there is a board that speaks of how it was destroyed by the Portuguese. Why are Indians continuing to justify what the Portuguese did to us? How are we related to Portuguese? How does, or which canon of secularism requires us to be faithful to what the Portuguese did to the native traditions of this land? And what sentiments, whose sentiments, and which religious sentiments are being protected here when the Portuguese were responsible for this? If the Turks come and destroy this, why am I supposed to be faithful to the Turkish sentiment? They have converted Hagia Sophia into a mosque when it was originally meant to be a pagan site of worship, converted by Christians, then converted by the Muslims. My point is, why can't people talk of reversion to the pagans, to the heathen, to the kafir? I'm sorry, we need it back. We want it back. Our right over these places continue, and we will continue to agitate for it. And as someone said in the course of a movement which was last a few days ago, ना कुछ भूला है, सब कुछ याद रखा जाएगा.
हम भी याद रखेंगे, हमें अल्जाइमर्स नहीं है.
Ravi ji, one question again. Let's say ideally all our temples are freed and funds are being managed by temple or the different Hindu communities themselves, the sampradaya and all. So how do you see in an ideal situation, how are you going to spend that money for the betterment of Hindu population? What is happening right now with that money? Is it going to cultural ministry and eventually ending up a scholarship to madrasas and all, because it is all one corpus kind of thing where all these kind of taxes are going somewhere else? And I don't know that if madrasas, mosques or churches, they are donating money to government so that they can take it back as scholarship or missionary activities and other stuff to be managed by that. How do you see that in an ideal situation? You're not
See, the good thing is that for an ideal situation, we need not invent something. We really need not invent something. We have enough historical examples for how the temples used to function and how they used to contribute to the society. I would just give 2-3 examples. The first example is the very temple about which we are talking now, Sree Padmanabhaswamy Temple. Now, this temple belongs to a specific sampradaya, which is Parashurama Paddhati. And though they belong to a particular sampradaya, the temple has literally provided for the people of Thiruvananthapuram and its suburbs over several centuries. The temple had a Annadana center attached to it, which was called Agrashala. And this Agrashala used to feed thousands of people every day. And this is the temple which literally supported n number of artisans and various artists, whether it be folk artists or classical artists, it doesn't matter. All these were supported through the various festivals, through the various ritual offerings. In fact, there were a list of cultural offerings to be made in the temple, in the sense that particular dramas, particular dance forms, particular music, various music varieties that you have, not just the Carnatic music but even the folk music, very specific you can say pieces of literature, and sometimes a particular community was given the right to do certain performances in the temple. And this was not even restricted just to those who were allowed to enter the temple, because there was a time when the Harijans were not allowed inside the temple. But the Agrashala, which was attached to this temple, used to give food to anyone and everyone, be it a Brahman, be it a so-called Harijan, I mean from the depressed classes. So much so that even in the late 19th century, when people, I mean the Musalmans of the erstwhile state of Travancore, when they used to travel for Hajj, they will gather at Thiruvananthapuram and they will leave from Thiruvananthapuram to Mecca. And the practice was that when they were staying in Thiruvananthapuram for a day or two, their food used to come from this temple only. Imagine this. Prasadam of Padmanabhaswamy Swami was given as food to Haji. I think I'm lost. Ah. So, can you hear? I'm
Yeah,
unable to
yeah,
hear anything.
yeah. Go on.
Okay. Yeah. So, this was how the temple used to function. And when famine used to happen in the erstwhile princesses of Travancore, it was this temple and the various other temples which used to serve the masses. So much so that in 1875, when the Great Famine of southern India happened, more than 10 million people died. Travancore was the only state where you find a very negligent number of deaths. And this happened because the temples served their purpose properly. So, and a temple was not merely a place of cultural arts and or merely socio-cultural things either.
Hmm.
Temples used to have colleges and schools attached to them. Temples used to have hospitals attached to them. The Sri Ranganatha Swami Temple of Srirangam, as well as the Brihadishwara Temple of Tanjavur, they had hospitals, even veterinary clinics attached to the temples.
Hmm.
There was a proper Ayurveda Shala attached to Ranganatha Swami Temple, where you have uh, a special shrine for Dhanvantri, who is considered as the god of Ayurveda. Now
Hmm.
the shrine exists, the temple doesn't exist. Of course, under the government control, you cannot expect anything to exist, not even Goshala, let alone Ayurveda Shala. And you call out colleges in the same Travancore state, in the today's district of Kanyakumari, which falls within Tamil Nadu. One particular temple of Krishna had a education of higher studies in not just in the Vedic studies, but in all other whatever subjects were available in that time, be it literature, be it astronomy, mathematics, political science, warfare. It was a university of higher studies which was attached to this temple. So what people tell us these days, that temple money is not used for public welfare, that is only because you are not allowing us to handle our money. Temples were actually the primary uh, place of Hindu economic power, and this has been alienated from us. While in the northern India, unfortunately, the invaders destroyed the
We have nothing
economic
left.
and cultural centers of Hindus. Of course, you still have temples left in Uttarakhand, but then they are
Yeah,
being taken away.
yeah,
I mean, Malviya ji mentions how Badrinath temple owned 282 villages. I
Hmm.
mean, 282 whole villages were owned by this one temple.
Hmm.
So, of course, some have escaped there, but most of them have been lost. While in
Hmm.
southern India, fortunately, due to the existence of Vijayanagar and the later Nayaks, and of course, even the Maratha rule of Tanjavur, these temples were saved. Uh, but unfortunately, we don't have control over these temples here.
Hmm.
So, where the others are able to utilize the funds of their institutions for uh, propagation and practice of their religion, and to show themselves as people who are very interested in social welfare. Unfortunately, I am not able to use my money to propagate my dharma.
Hmm.
So that is the uh, unfortunate reality. So that the truth is, if the temples are in the Hindu hands once again, they can very much undertake all these activities. And two examples are there for these activities happening even now. One, and interestingly, both of them are in coastal Karnataka that I'm going to give you. One is Udupi Sri Krishna Temple, where 50,000 people are fed every day. The in the temple, the entire schools in Udupi get food from the temple. Almost 3,000 patients in the Udupi town are getting fed their daily lunch and dinner from the temple. They are being fed by the temple. And this Udupi Krishna temple has its own schools. They have their educational institutions. They have a Goshala. Who said that you cannot do these things? It can happen, provided the temple is within yours, in your hands rather. The other example is Dharmasthala. So Dharmasthala is a beautiful example of how the Hindus used to manage their institutions earlier, and even a unique amalgam of various traditions become a sampradaya of its own. This is a Shiva temple, which is very, very holy to the Shaivites of Karnataka, and for that matter, entire southern India. But the pujaris of this temple belong to the Vaishnavite sect of Madhva Sampradaya. The Dharmakarta or the trustee of the temple is a Jain. What
Okay.
brings them together? There is a specific puja paddhati of this temple, and all these three people believe in that paddhati and they follow that paddhati.
Mhm.
And Dharmasthala again is an example where they have education institutions. They even help other old temples to be revived. Uh, they feed like anything. I mean, the amount of annadana which happens in that temple is phenomenal. Second only to Udupi in entire coastal Karnataka. So you have cases where the temples are with Hindus and they are being managed extremely well.
Hmm.
So it is
Okay.
not anyone's case that it is impossible to do.
Okay, now we are going to take some live questions, and the first question is on the screen. If you are able to see it, while apparently reinstating the rights of Travancore royals, the conditions and terms will lead to temple to be dependent on state government to make ends meet. Is it true?
I will just add something here. There was another
Yeah.
headline related to this. There was another headline that said that the verdict can reduce the rich temple to go to communists with a begging bowl.
Yeah.
And it basically focused on the temple having to pay for its security,
Right.
and the fact that a 25-year audit, I believe, has been ordered.
Right.
So I think that is what the question really means.
So let's understand what are the practical downsides to the judgment. Okay, the security expenditure that I think they have spoken of, where they say that the Supreme Court has said that the temple must bear its own security expenditure. Now, this is what happens when someone wants to say something without knowing what the ground realities are and what are
Hmm.
the ways and means possible. Okay. Now, there are two sources of state funds, not state funds, funds which come to this particular temple because of the lands taken over of the temple by the state government. Okay. So, this particular temple receives an annuity of 58,500 for over 12,000 hectares of land. And Raviji is welcome to correct me here, annually for this particular land. And we pointed out to the Supreme Court that you have increased the infrastructure of this particular temple after the state has taken over during the 9-year period when the state government was providing all the security. And thanks to all the treasure talk that you have been indulging in for all these years, you have increased and enhanced the security risks of this particular temple. And today you're asking us to bear this particular expenditure, which you are responsible for. Okay. So one of the things which is possible is the state government as well as the central government must take responsibility, because you have the Ministry of Culture which is doling out grants for all sorts of Mughal architecture and whatnot under the sun. Okay, can provide for security of this particular temple, because until this talk of treasure came out in the public, the temple was secure. But today it is in the hit list of anti-social elements, it is in the hit list of terrorist organizations because of what you have done. So, as far as we are concerned, this is something that is capable of being taken up with the state government. And there are any number of people on the ground who happen to be strong votaries of this particular institution, the temple, and the people who are stakeholders of this particular temple. I don't deny that this is one thing that the Supreme Court ought to have been cognizant of. But since some people are not aware of what are the ground realities and how is it that certain ways and means can emerge based on what happens, because you see, more than anything, these people should know that not everything happens in let's say in public consumption and daylight. Okay, any number of legitimate options can emerge, because now that the government is out of the temple and the control is in the hands of the Maharaja, it is possible to rally around public support for the purposes of meeting these expenses. But let me come to the direct answer. There are two levels, in fact. The temple gets a certain amount, I think about 6 lakhs or even more, as part of the
20
covenant.
lakhs now.
20 lakhs now, sorry, 20 lakhs as part of the covenant obligations, which the Indian government has taken upon itself under Article 290A thanks to the obligations that it has received from the Maharaja of Travancore when the temple as well as the state were acceded to the Indian Union. So the Indian government, if it is truly intent on helping temples or at least doing something for this particular cause, the Ministry of Culture can legitimately expend money towards the security of this particular temple, and the state government can increase its annual contribution, which remains at 58,500 for prime land of 12,000 hectares. Okay, so these are two aspects. Even before certain armchair geniuses pointed out these aspects, we have started working out on this particular issue. So unfortunately, what is the problem with these sentiments is that the sentiments are effectively aired at not presenting a certain solution, but in downplaying the victory that this particular judgment represents, because it represents reversion of control to a Hindu hand. And that is something that most people, for some jaundiced reason, are not able to even view, for some myopic reason. So this is something that is capable of happening. What was the second question that you asked? I'm so sorry. I think this is the one, right?
Yeah,
Nupur,
that's
you
it.
That's only.
Yeah, I have a few more questions from Twitter, which I'll just ask. What
the
is stopping?
discussion has been going on for 1 hour and 17 minutes. So wrap it up in like 13 minutes. So yeah.
Okay. So one question is, what is stopping from every government from bringing in a legislation which frees Hindu temples, since it's been a Hindu demand for so long? What stops the government from doing so? Every successive government.
So I have written a piece for the Open magazine, which should be published tomorrow. It's about 3,000 words, where I've addressed this particular issue. Because here is an instance where the central government took part in the proceedings before the Padmanabhaswamy court or the bench from 20th of March 2017 until the conclusion of arguments. No position was taken with respect to Articles 25, 26, or even with respect to state control, because as part of our oral submissions and written submissions, we pointed out to the court that the state has not exactly covered itself in glory for it to actually stake a claim to manage the temple, because there are over 1 million pending audit objections in several places. Okay, and therefore we basically submitted to the court that only a party which has a decent track record of administering temples can actually stake a claim for it. How is the state even remotely qualified? Because it seems to have done an abysmal and a shoddy job, if to put it mildly, as far as administering temples are concerned. Even then, there was no representation from the central government. Now, does the central government have the constitutional standing to speak on the subject? Yes. Entry 28 of the concurrent list of the Constitution effectively ensures that the union government can take a position on it, and a position taken by a union government on a subject which falls under concurrent list must prevail and prevails over the state legislation. So the center can pass a central legislation with respect to freedom of temples. What is lacking is not constitutional competence. What is lacking is not numbers, but what is certainly lacking is the most key ingredient: political will and intent and political incentive. So I don't think that the center sees an incentive in freeing temples from government control. Otherwise, what explains the takeover of 51 temples under the Char Dham Act in Uttarakhand, where the central government's party is in power? Okay. So frankly, while some have basically tried to give the impression that this entire movement is anti-Congress or let's say anti a certain dispensation, अरे भैया कांग्रेस बचा कहाँ पे, किस स्टेट में है? Okay, matlab they are effectively going around with a begging bowl. They have no state where they're actually in power of significance. Very few states, and even in 1 or 2 states where they're actually in power, उनका तो वहाँ पे भी हिल डुल रहा है. राजस्थान हो या कहीं और पे हो, मध्य प्रदेश का भी हो गया, right? So who are we now? Therefore, it is downright stupid and patently idiotic to reduce this to a political discussion where it's whether it is one party or another party. This is not about the party. This is about the community. And for those people who are unable to strike a distinction between the party and the community, I'm sorry. My sympathies are with you, because you can't seem to go beyond that myopic vision. Your priorities, आपको मुबारक हो, आप जो करना है करें, बस हम पे आपके ओपिनियंस को थोपिए मत. हमारे लिए पार्टी अलग है और कम्युनिटी अलग है. कम्युनिटी सबसे पहले है.
अब एक क्वेश्चन many people are asking is basically कि अयोध्या तो झांकी है, काशी मथुरा बाकी है. So when are we going to take them back? What are the, have we started it on it, in full force, or are we just gathering strength and waiting for a mass movement like that happened in with Ram Janmabhoomi?
all Indic intellectuals should put together a strongly worded representation along with signatures and send it to the Ministry of Culture and the Union Ministry, and basically say that the Places of Worship Act is an impediment and is a blot on Indian history, and this is adding insult to the injury of those who have lost their religious sites. So kindly repeal it. वरना बेकार में हर मंदिर के लिए आप जाके कोर्ट में लड़ते रहेंगे क्या? और कोई काम नहीं है. If you continue doing that, तो फिर आप संस्कृति की रक्षा कब करेंगे अगर आप यही करते रहेंगे? Ultimately, temple freedom is a means to an end, not an end in itself, right? And you please tell me, how do you expect the community to constantly find the will to keep fighting this battle in several courts? कौन करता रहेगा, इसकी जिम्मेदारी कौन लेगा? यही तो सवाल है, right? ब्रॉड इश्यू पे तो बात कर सकते हैं, लेकिन अल्टीमेटली व्हेन इट कम्स टू एक्शन, 1000 लोग बात करेंगे, 500 लोग सर हिलाएंगे, 50 लोग आगे बढ़ेंगे, 5 लोग काम करेंगे. तो ये ऐसे ही होता है ना. ये तो टेलीस्कोप की तरह हो गया ना, उल्टा टेलीस्कोप है ये तो. Okay. So the better thing would be that the leading voices of the community, the Peethadipatis, the Dharmadipatis, and everybody who matters should effectively tell the government what is stopping you. और कितनी सीट चाहिए? 303 तो मिल चुका है ना. तो आप करिए, काम कीजिए and get us what we want. We have been waiting for it. But nobody wants to talk about this. एक राम जन्मभूमि जजमेंट को दिखा के ये कहने कि हमने ये कर दिया, हमने कर दिया. अरे भाई हो गया, वो हो गया, आगे बढ़िए. 40,000 टेम्पल आपके लिए वेट कर रहे हैं. सबको आप विमुक्त कीजिए.
I think one question that comes up repeatedly, and I have a couple of tweets which are variations of that question. And it's again, I'm playing the devil's advocate here because I'm pretty sure the people who've asked these questions are not really dharmic. So the question is that a direct consequence of freeing Hindu temples from government control would be increased casteism as far as places of worship is concerned. So basically, if Hindus are free to control their own places of worships, we would indulge in casteism. We would oppress the so-called lower stratas of the society and not let them enter the temple. Whereas if the control is with the government, everybody would be allowed. So this is what I said, that I'm playing devil's advocate. I'm pretty sure these people are not dharmic, but let's take that.
बहुत सारे धार्मिक भी हैं जो ऐसी धारणा रखते हैं क्योंकि वो कुछ पढ़ते नहीं है. Okay.
So let's take this up anyway.
I'll tell you what the issue is. Okay, government took over the Travancore temple, the Padmanabhaswamy temple under the instructions, or let's say under the setup provided by the Supreme Court between 2011 and 2020, and before that it was in the hands of the family. Okay. Please tell me what instances of casteism were they able to identify until 2009? मैं एक दशक के पहले बात नहीं कर रहा. I'm not talking of a century ago. एक शताब्दी के बारे में बात नहीं कर रहा हूँ. 2009 की बात कर रहा हूँ. Okay. Secondly, जो मंदिर अभी फ्री है, okay, दिल्ली में तो बहुत सारे मंदिर तो अपने आप चल रहे हैं. ये लोग क्या बात कर रहे हैं? दिल्ली में जितने भी मंदिर हैं, कालका जी का मंदिर हो या कोई भी मंदिर हो, all these temples are free, right? Now, what casteism are you talking about in those temples? अरे at least example और उदाहरण के साथ तो बात करो. And here's the interesting part. To legally unlettered people, here's my response. अगर कभी मौका मिले, संविधान को पढ़ लेना, ये बहुत ही जरूरी है. Article 17 abolishes untouchability. Legislations penalize untouchability. The concept of untouchability within a temple is impossible. Okay? And you have to name and give me instances of untouchability in temples that have been practiced in living memory in modern times. अगर नहीं है तो ये बेकार के स्पेकुलेटिव सवाल करना बंद करो, काम की बात करो. Okay. Second, very same Article 25, Article 25(2)(b) facilitates and mandates the entry of the previously untouchable classes inside the temple. तो अगर आर्टिकल 25 पढ़ना है और कभी संविधान नामक एक बुक को खोलोगे, उस किताब को खोलोगे, तो उसमें आर्टिकल 25 देख लेना. अनुच्छेद 25 में सब आर्टिकल 2 है, उसमें सब क्लॉज बी है, उसको आंखें खोल के पढ़ लेना. इट स्पेसिफिकली सेज दिस इज नॉट परमिसिबल, दे विल बी अलाउड इनसाइड. ओके. ना कोई ब्राह्मण, ना कोई क्षत्रिय, ना कोई वैश्य, ना कोई और किसी और को रोक सकता है मंदिर में प्रवेश करने से. ये आप समझ लीजिए, ये बिल्कुल नहीं हो सकता है. गर्भगृह के अंदर कोई नहीं आ सकता है, चाहे वो कोई भी हो, बिकॉज दैट इज सैंक्टम सैंक्टोरम. लेकिन मंदिर के अंदर हिंदू आ सकते हैं as long as it's a public temple and it's not a private temple. Okay, that's one. Two, frankly speaking, it almost I mean, the impression that is given, and this is according to me an internalization of Vampanthy history, which is to basically say Bin Qasim invaded Somnath to effectively protect the downtrodden people because they were being oppressed by Brahmins, is the new nonsense that is being peddled. And we seem to have bought the very same nonsense to basically say that no, the state is entered to effectively do this. That state which indulges in caste arithmetic during elections, you're telling me that state is going to do social justice? जब इलेक्शन की बारी आती है तो जातियों के नाम पे ही तो आंकड़े बनते हैं, तो ये करेंगे जस्टिस मंदिर में जाति के नाम पे? किस, I mean, what are we talking about? So put faith in the community. Stop putting faith in the state on these particular issues. The state which you don't trust when it comes to other aspects, you're willing to trust it with your nerve center of your Indic identity. That effectively shows the kind of the depth of the burial ground that you've stuck your head into. Okay, thoda na, we have to read, we have to effectively open our minds, because ये सवाल ना घिसे पिटे हो चुके हैं. At least कुछ तो imagination हो, कुछ तो out of the box पूछे. The kind of questions that these people keep asking, it tells me that यहाँ से कुछ सुन लिया, वहां से कुछ सुन लिया, और जो सबका ओपन यूनिवर्सिटी है, व्हाट्सएप यूनिवर्सिटी, उसमें से कुछ पढ़ लिया और बस वहां से सवाल चेप लिया. अरे भाई, थोड़ा दिमाग इस्तेमाल करो. दिमाग इस्तेमाल करने से पिघलता नहीं है, खर्च नहीं होता है. Okay, so do it.
Okay, Ravi ji, answer this question. Instead of fighting for removing government control over temples, why not argue for government monitoring all the religious structures, temples, churches, mosques, etc., irrespective of any religion? All of them can be appropriately taxed. This is Apur Samayar who is asking this question.
Okay, so just because I am illegally arrested doesn't mean that I want the entire population to be illegally arrested. Okay?
Good analogy. Yeah.
I mean, what the government is doing to my institutions is absolutely horrible, and is freedom to practice my religion. See, look at the way the Muslims organized themselves in the 1920s. They did not care about what happens to the Hindu institutions. They wanted their rights to be protected. So why can't the Hindus think of their own rights? Why do we cry about what happens to the other institutions?
Correct.
I mean, उनका भाड़ में जावे, मुझे क्या फर्क पड़ता है?
सही बात.
What matters to me is that my temples should be protected first. Let me take care of my burning house. I mean, instead of putting down the fire and putting out the fire in my house, I want to go and put fire on the neighbor's house. What is the point in it? And even if I do it, let me put it this way. Even if you're going to do it, the others have sources of income which can support their NGO activities, which can still ensure that they do their propagation of religion, their missionary activities and whatnot. We don't have any such source of income. Our source is our temple only. So you will be completely defenseless, while the others won't even be so defenseless. So even if you really want to say that everyone has to suffer similarly, it will be an unequal suffering only, and the other side will have weapons to beat you with.
So here I want to just forget about this. Please let us internalize that Hindus are a global minority, whereas others are not. Okay? Therefore, if all of you are subjected to the same treatment with respect to your religious institutions, one global minority is being subjected to a condition which it is not in a position to compensate for from outside the country. Okay? Therefore, when people are willing to go to Al Jazeera and Qatar and every other place to effectively talk about what happens in India, clearly they are thinking beyond India. A lot of people. Okay? आप कहां पे जाएंगे? नेपाल के पास? आपके हाथ से नेपाल भी जा चुका है. कहां जाएंगे? So my point is, the one Hindu country that was there, वो भी आज कम्युनिस्ट के हाथ में जा चुका है और वो चाइना के गोद में जाके बैठ चुका है. So focus on improving your lot. So which is why the one thing that I say is that the movement for temple freedom does not impact any other community. So we are constantly stuck in the fact कि उसको भी एक झापड़ पड़ रहा है, मुझे भी एक झापड़ पड़ रहा है, then therefore I'll be happy with it. The stupidity of constantly miring everything into Hindu-Muslim nonsense needs to go, because even there it shows lack of guts. You're not saying I want to have the same extent of freedom to the other side as the other side. I want to be imprisoned, or they must be imprisoned to my extent. This inverse logic that is applied, ये ना एक तरह की विकृति है. ये हिंदू दिमाग की एक निशानी है, according to me. Okay, only Hindus are capable of thinking like this.
Okay, I think we'll wrap up with my last question, which is slightly more personal and not legal. And this goes to Sai and Ravi ji both. What do you see yourselves as? Do you see yourself as a lawyer, Sai, or do you see yourself as an activist? And where does the lawyer stop and the activist begin? Or where does the activist stop and the lawyer begin? And the similar question for Ravi ji. When did you really get into this activism with People for Dharma, and what was the one thing that motivated you to start this organization? So I think first Sai can take it up, and then Ravi ji, and then we can close.
I'm not an activist. I don't subscribe to that particular concept because आपका परिदृश्य से बिगड़ जाता है. Your objectivity is affected because of that. Okay. Assume for a moment an affected party asks for redressal of his grievance. Is he being an activist? No. I believe that everything that I suffer as a Hindu, I'm not just suffering it at a communal level or a community level or a societal level. I'm facing it personally because these are institutions that belong to my community. I don't need to be an activist to be able to air these concerns. I am an active Hindu. I'm a conscious Hindu. I'm a practicing Hindu who fortunately has legal training, who spent about 11 years yesterday or day before yesterday, I finished 11 years in the profession. And I have established myself as someone who can hold his own when it comes to this particular subject. So for me, my pro bono commitment to my profession as a lawyer is my commitment to Dharma. Okay? So I don't see myself as a Hindu lawyer. I don't see myself as a Hindu activist. I see myself as a Hindu who is a lawyer and a lawyer who is contributing to Hindu causes wherever he can. Okay. But the word activist, the problem with that is an activist will effectively portray this judgment as perhaps 100% victory. There will be no sense of objectivity in looking for the grace in the judgment. Okay.
Yeah.
So, which is precisely why I reinforce my credentials as a lawyer to stay grounded, to stay real, and to stay very, very, let's say, pragmatic about what's possible, what's not, what is achievable, and what's not, and constantly push the boundaries on that particular front. Okay, that makes me an active Hindu, not an activist Hindu.
By the way, one last request for you, Sai, which I got on Twitter, is that please get J. Sai Deepak to write for OpIndia regularly.
अच्छा, ये आप किसी और के कंधे से क्यों चला रही है तीर?
नहीं, बिल्कुल मैं. But this is a genuine tweet, so you can say no to me, but not other people, which is why I read it out to you.
Okay, so those who actually said this, assuming that it's not you, आंखें खोलो, पढ़ लो, मैंने इससे पहले भी लिखा है.
Regularly, Sai, regularly.
ठीक है, done.
Operative word.
Done.
Ravi ji?
Okay. See, in my case, perhaps it has been some 20 years since I started taking interest in Hindu issues, be it politics or the religious side of it. Though I was not really, someone who wanted to go to the court or anything. I used to write blogs. I used to debate with people. I used to contribute to the local community. So that was the limit of my engagement. But perhaps you can say the last straw on the camel's back, or the real huge kick which pushed me into this formation of People for Dharma was the Sabarimala case. What happened in the Supreme Court in Sabarimala when the arguments started, and when our dear Arnab Goswami started something called Right to Pray, and the way they were portraying the temple's traditions as though there is nothing but misogyny associated with the temple, uh, never caring about the historical aspects of anything that they were talking about. For example, they even claimed that the temple is funded by the government, for God's sake. Uh, Not even understanding why the payment was being made to the temple, because the temple's lands had been alienated by the government. The government is paying a compensation which is already a pittance compared to the actual compensation they were supposed to pay. The fact which really uh, pricked me a lot was that no one cared about truth and no one cared about justice for Hindus. And the few of us who could understand where these practices came from, and a vast majority of the masses without even knowing the history behind the practice, but they could understand the reason behind the practice. Because of them being practicing Hindus, they did not have any voice in the Supreme Court. And that is what pushed a few of us to try and place our arguments in the Supreme Court, and perhaps even before the media, to give a balanced view of the facts. And here I should be very, very thankful to Sai Deepak ji, because when we decided to do it, I had no idea about how to hire a lawyer, what is the process of filing a petition in the Supreme Court, intervention petition क्या होता है, writ petition क्या होता है, कुछ पता नहीं था मुझे. I did not even know that you require a advocate on record to file a petition in the Supreme Court. So they were clueless. We knew only about facts regarding the temple. We had read something about the constitution. We had read some of the old judgments to arrive at what could be placed as arguments. But above that, we knew nothing. And it was purely desperation, you can say, because we were afraid that if a popular temple like Shabarimala can be thrown to the wolves in such a manner, then every other temple would face a similar problem. It is, floodgates being opened, and the Hindu temple tradition being destroyed in a matter of years, if not decades. I would say it was only years, certainly not in decades, because that was the situation we were envisaging at that time, looking at what was happening, which is the only reason why we started this. We wanted to put an end to this nonsense. And Sai Deepak ji, when we called him up, I'll be very upfront. I told him, sir, we are all middle class people. We have no money. We might be able to pay only some pittance. I'm very sorry. Can you please argue for us? And he gave us a reply that he would argue only pro bono for dharmic causes. I am certainly not going to look in the mouth of a gifted horse or whatever. So, and I'm very thankful for that. I would say it was perhaps the Devata's wish that we had to approach Sai, because since then there has been no looking back, and we started with this. Then the next case we came to him with was Padmanabhaswamy. And even at the initial time when we went to him for Shabarimala, we thought it was a one-time engagement. My brother and myself, we visited Padmanabhaswamy Temple. We saw the nonsense that was happening there, because the royal control had been removed from the temple. And we were so upset with it. We looked at the amicus report. We looked at the various interim judgments which are being passed. So with some trepidation, I had approached Sai again, and I asked him whether he will be ready for another case. And he told us that he's ready for a number of cases. And that's how it started. So we went with the decision that we will join Padmanabhaswamy case as well. And after that, it has been a group decision. We sit together as trustees. We identify causes where we think we can do something. We approach Sai for his opinion. He's our legal mentor, to be honest. So he suggests what can be done and whether something cannot be done. And based on his suggestion, we take the step forward. And I think we are doing extremely well compared to whatever we were expecting when we started this. So that's how it started, and I'm actually happy because perhaps I should have also. I mean, that's what people tell me. Sai knows it. I have lost some opportunities because of this. There are people who have called me an idiot, a moron, as someone who doesn't care about family. But to be honest, my family supports me, and I am happy about what I do. I don't have a feeling that I am a mere spectator. I'll end this with this statement. The Dharma Shastras say that it is not merely the criminal who is going to partake in the papa, but even those who are silent spectators of the crime. So, till I joined the case, I was a silent spectator, to be honest. I was not able to do anything. It was something which used to uh, burn my conscience. Since I started People for Dharma, at least my conscience is free. I'm not a silent spectator. I'm trying to do something. I don't say it is excellent, it is extraordinary. I don't say that it is the best I could do, but at least I'm doing something. And that gives me a peace of mind that I at least try to walk in the path of Dharma. And that is perhaps the greatest objective that I can have for my life.
ओके अब मैं जो है कुछ लोग, बहुत सारे लोग इनफैक्ट बोल रहे हैं कि हिंदी में इसको थोड़ा सा रैप इट अप कर दीजिए, सारांश बता दीजिए क्या हुआ। और सबसे पहले तो आप दोनों का आई वुड लाइक टू थैंक बोथ ऑफ यू, रवि जी एंड साई जी, दैट you have given your 100 minutes of your more than 100 minutes of your busy schedule and talked on various aspects of this particular case and Hindu temples in general. अब मैं हिंदी में अपने व्यूअर्स को कुछ बताने जा रहा हूँ। अगर आप लोगों के पास समय है तो रुक सकते हैं, नहीं है देन आप लोगों का बहुत आभार जुड़ने के लिए। और यहाँ से मैं पूरा एक सारांश यही है कि सबसे पहली बात है कि जो हुआ ये पद्मनाभ स्वामी टेम्पल के केस में, वो कल्मिनेशन है बहुत सारे लोगों के एफर्ट्स का। डिकेड्स ऑफ लॉयर्स लड़ते रहे इस केसेस को और हमेशा धीरे धीरे हम जीतते रहे, जिसके बारे में अनफॉर्चुनेटली हमारे पास मीडिया में खबरें नहीं आती, या वामपंथियों ने इतिहास या उपन्यास के रूप में इतिहास को लिख दिया है, तो इस कारण हम जान नहीं पाते हैं कि हमारे लिए कितने लोग पास्ट में, हमारे बाप दादा परदादा चाचा, इस तरह के लोग खड़े होते रहे और उन्होंने इस लड़ाई को लगातार लड़ा है। दूसरी बात जो साईं जी ने बताई कि हमें जो है मास मूवमेंट क्रिएट करना होगा। ये खाली फ्री टेम्पल वाला टी शर्ट लगा के और यो टाइप का स्टेटस लिखने से उससे नहीं होगा, अनलेस यू मेक पीपल अकाउंटेबल एट लोकल लेवल। तुम सबसे पहले अपने मुखिया से शुरू करो, जिला परिषद के लोगों से शुरू करो, विधायकों से प्रश्न पूछो, सांसदों से पूछो, उसको घेरो बिकॉज ही डजंट रिप्रेजेंट जस्ट योर आइडियोलॉजी, तुम्हारा पॉलिटिकल आइडियोलॉजी नहीं, वो तुम्हारे लिए आगे जितनी पॉलिसीज बनेंगी, और पॉलिसी में ही बनता है कि तुम्हारे जो हुंडियों में पैसा आ रहा है करोड़ों रुपया, बालाजी मंदिर है और तमाम मंदिर जिससे सैकड़ों करोड़ जाता है। मतलब बताइए कि अभी जगन्नाथपुरी वाले टेम्पल के केस में हो रहा था कि नहीं रथ यात्रा जो है रोक दिया जाए, वो सारे ऑप्शन दे रहे थे, स्टिल जो है गवर्नमेंट वाज नॉट बजिंग। लेकिन वही एक दिन का मूवमेंट शुरू होता है और गवर्नमेंट तुरंत अपना पोजीशन चेंज करता है, उड़ीसा गवर्नमेंट, एंड देन दे आस्क फॉर कि ठीक है हम जो है कोविड का है तो उसका प्रिकॉशंस लेके हम चलेंगे। तो ये तो मैं बहुत ही मतलब रिसेंट एग्जांपल बना रहा हूँ कि एक दिन ट्विटर पे मूवमेंट चला है एंड द लॉयर्स हैड टू टेक यू टर्न टू गिव इन टू द बिलीफ्स ऑफ पीपल। तो इस तरह से जब तक वोकल होके, और वोकल मतलब सीरियस होके, तुम देखो ना लोगों को कि सुप्रीम कोर्ट का जजमेंट है कि लाउड स्पीकर नहीं लगा सकते हो, कितने जगह से हट गया लाउड स्पीकर। सड़कों को एक खास दिन में बिछा नहीं दिया जाता है रंग बिरंगी टोपियों से और तरह तरह के मतलब नमाज पढ़ने के लिए। तो उसके ऊपर किसी ने बोला कि वो तो तुम हमारे संवैधानिक राइट्स को ट्रैम्पल करना हुआ। somebody is doing that and you are standing just as mute spectators और बाद में ट्वीट करते हो यार देखो हमारे सड़कों को ये लोग जो है शुक्रवार को पाट देते हैं। तुमने क्या किया? तुमने प्रोटेस्ट किया उसके लिए? नहीं किया। मैं ये नहीं कह रहा हूँ कि दूसरे लोग क्या करें, जैसे रवि जी ने बताया, यू डोंट हैव टू थिंक अबाउट अदर्स कि उसके चर्च से पैसा क्यों नहीं दिया जा रहा है, मस्जिद से। तुम अपने मंदिरों को बचाओ कि जितना पैसा आ रहा है हैव दैट फॉर योरसेल्फ। ऑर्फनेजेस खुलेंगे, विधवा महिलाओं की रक्षा के लिए खुलेंगे। आप देख रहे हो ना जितना एनजीओ है सब में हम फीमेल एक्सप्लॉइटेशन और मतलब इतनी खराब खराब बातें हम सुनते हैं। जितना एनजीओ है जो लड़कियों को रखते हैं और बाद में पता चलता है कि ऑडिट आप करके देख लीजिए और वहां लड़कियां इतनी भयावह बातें बताती हैं कि हमारे साथ होती हैं। तो यू नीड टू गिव दिस टू टेम्पल को पैसा दो, ऑर्फनेज खोलेगा, लड़कियों के लिए हॉस्टल्स खोलेगा, स्कूल खोलेगा, पशु पक्षियों के लिए अस्पताल खोलेगा। दुनिया का पहला बर्ड्स हॉस्पिटल जो अशोक के टाइम में खुला था। तो हमारी वो परंपरा और हमारी वो संस्कृति रही है। सो गिव दिस ऑल टू अस, हमें दे दो, हम मैनेज कर लेंगे। और जहां तक करप्शन की बात आती है, तो गवर्नमेंट खुद इतना ज्यादा करप्ट है, तुम कैसे, मतलब तुम तो पापी आदमी हो, तुम्हें तो बोलने का हक ही नहीं होना चाहिए कि आम जनता करप्ट है। तुम लूट के बर्बादी फैलाए हुए चारों तरफ, और ब्लेम तुम आम जनता पे कर रहे हो, उन पुजारियों पे कर रहे हो जो बेचारा भगवा वस्त्र पहन के निकलता है, उसको 200 आदमी लिंच कर देते हैं पालघर में। रिसेंटली अभी मेरठ में मार दिया एक पुजारी को, क्योंकि उसने भगवा जो अंगोछा पहना हुआ, गमछा पहना हुआ था। तो तुम तो अपने पड़ोस के पुजारी तक को प्रोटेक्ट नहीं कर रहा, तुम खाक टेम्पल को प्रोटेक्ट कर पाओगे? जब तक ये सेंसिबिलिटी नहीं आएगी कि ये हमारा डेटी जो है वो एक पत्थर की मूर्ति नहीं है, वो पूरे ब्रह्मांड का देवता है, ही कंट्रोल्स एवरीथिंग। अगर तुम अपने आप को हिंदू कहते हो, नहीं कहते हो तो वेल एंड गुड, अगर कहते हो देन यू शुड बी एबल टू टेक अ स्टैंड, और वोकल ही नहीं, तुम्हें सड़कों पे निकलना होगा। वो चोर के लिए 1 लाख लोग, मतलब झारखंड में एक चोर मरता है, 1 लाख आदमी सूरत में कैसे निकल जाता है उसके खड़े होने। तुम क्या करते हो? तुम लिखते हो, ट्वीट करते हो, लिबरल चुप क्यों है? भाई लिबरल तो चुप ही रहेगा, लिबरल का वही है। और एक एस्पेक्ट है टेम्पल एज ए टूरिस्ट प्लेस, उस पर भी बात हुई कि टेम्पल टूरिस्ट प्लेस नहीं है। जस्ट बिकॉज आई हैव अ नाइस हाउस, मैंने बढ़िया घर बनाया, उसमें स्विमिंग पूल है, डजंट गिव एनीबॉडी राइट कि तुम आके कूद के उसमें स्विम करने लगे। तो वही टेम्पल है। टेम्पल जो है डेटी का होता है, भगवान का है, देवता का है, और देवता ही डिसाइड करेंगे कि उसको कैसे रन किया जाए, उसके पैसे कैसे स्पेंड किए जाए, उसमें कौन से लोग आए। तुम्हें देखना है, तुम बाहर से फोटो खींचो, सबरीमला में जाना है, बाहर से फोटो खींचो, यू डोंट हैव एनी राइट टू एंटर इट विदाउट द प्रॉपर, उसका जो पूरा प्रोसेस है, फास्टिंग का प्रोसेस है, कैसे आना है उसका प्रोसेस है, किस तरह का भोजन तुमको करना है। तुम यहाँ पे कल को कहने लगोगे ना कि मैं गाय का मांस खाता हूँ, मैं मंदिर में बैठ क्यों नहीं खा सकता हूँ, ये मेरे राइट टू ईट के ऊपर जो है एक अटैक। ये भी लोग कह सकते हैं, क्योंकि हिंदू तो यही, हमें सर्व समावेशी के चक्कर में हमने यही नौटंकियां की हैं। और जैसे कि बताया कि मतलब हम इतने भोले भाले थे कि वी गेव इन, कि यार सरकार बदल जाएगी, यार सरकार हिंदुओं की तो होगी, हम लोग जो है इतने करोड़ लोग हैं, हमारे राइट्स को रेस्पेक्ट किया जाएगा। देख लो किस तरह से रेस्पेक्ट किया जा रहा है। आप दोनों का, सर रवि जी और साई दीपक जी, दोनों का बहुत बहुत आभार जुड़ने के लिए। और भी हमें मतलब ऐसे बिंदुओं पे चर्चा करनी होगी, तो आशा है आपका समय हमें मिलता रहेगा, और आशा करता हूँ कि मैंने जो हिंदी में बोला है वो आपको समझ में आया हो और मैंने कुछ
We should
गलत
end
ना
this
बोला।
video. We should end this video with ये तो अभी झांकी झांकी है, लाखों मंदिरें बाकी है।
40,000
Right,
मंदिर
right.
बाकी है, और उसको जो है रिक्लेम करना है। हम कुछ मतलब हम खींच नहीं रहे हैं, जैसे राम जन्मभूमि वाले में बोला ना कि बाबरी रोड, अबे बाबरी से पहले क्या था वो नहीं, मतलब इतिहास क्या 1528 से शुरू होता है? 1528 में तुम मस्जिद ला के जहां तहां रख दोगे, जहां तहां के दीवार को बना दोगे मंदिर, मतलब मंदिर के आर्टिफैक्ट्स को सीढ़ियों में डाल दिया। पाकिस्तान में तो मूत्रालय बना दिया, टॉयलेट बना दिया है मंदिर।
Ajit,
हम
we are
वो
not used
जानते
to
हैं।
listening to you live and putting our reactions on video. हम प्राइवेटली देख के हंसते हैं, वही ठीक है, इसीलिए साई भी ना ऐसे मुंह छुप पा रहा है कि
I'm loving it. I'm absolutely loving it.
हाँ, मेरा वही कहना है कि जब तक हिंदू वास्तव में जागेगा नहीं, और जागने से मतलब है बी वोकल अबाउट योर बीइंग हिंदू, और हिंदू होने का मतलब है कि टेम्पल उसमें आता है। हिंदू होने का मतलब चंदन और रुद्राक्ष पहनना नहीं होता है। हिंदू होने का मतलब तुम टेम्पल, तुम्हारे एरिया का जितना है, यू आर गवर्न बाय दैट वे ऑफ लाइफ। तो उस वे ऑफ लाइफ में वही अस्त्र शस्त्र शास्त्र सबकी शिक्षा दी जाती है, और उस हिसाब से अपने आप को प्रिपेयर करो। क्योंकि नहीं तो फिर 17 बार सोमनाथ को लूटा ना, तो उसी तरह फिर से लूटने के लिए तो लगे हुए लोग। एक तरह से गवर्नमेंट लूट ही रही है।
एक छोटा सा स्लोगन
जी
आजकल
जी।
ये चल रहा है ना, आत्मनिर्भर के लिए, बी वोकल फॉर लोकल। आई एम सेइंग बी
हाँ
वोकल
हाँ
फॉर टेम्पल, दैट्स इट।
हाँ हाँ, ठीक है। तो सबका आभार जुड़ने के लिए, और आगे भी इस तरह के हम करते रहेंगे, और देखते हैं कि हमारे 40,000 मंदिर कब फ्री होते हैं, और 40,000 मंदिर रिक्लेम कब करते हैं, बाकी जितने हमारे लाखों मंदिर हैं इनफैक्ट, तो वो कब फ्री होते हैं। बहुत बहुत आभार आप सबका। नमस्कार।
Thanks, Ravi.
धन्यवाद, नमस्कार।